They don't know the law. You know the law. You should uphold the Constitution, right? Yeah, you found me guilty without eviction.
Excuse me.
Yeah, you found me guilty without eviction. Violating the Constitution right, my Sixth Amendment.
All right, Mr. Williams, first, number one, you need to lower your voice. Number two,
went to trial, the jury found him guilty of murder, and he was sentenced to 30 years in 1997 on parole, and he tries to commit another murder. We are asking for the maximum life on this case.
22 CR 4751, State of Texas versus Kenneth Williams. Mr. Churek, are you ready to proceed?
I am, Your Honor.
All right, this hearing is scheduled at 9 a.m. It is 9:01. And I see that the state is not here. And have you discussed with Mr. Churek whether or not his client is going to plead true or not to the enhancement? Or no?
We haven't discussed that yet.
So, Mr. Churek, is he?
Yeah, he said that he would plead true. Hold on.
Yes.
Am I allowed to elaborate about it?
Your attorney is allowed to present whatever evidence he wishes to present.
Repeat offender enhancement allegation, and it is further presented in and to set forth that before the commission of the offense alleged above on the 19th day of December AD 1997 in cause number 1997 CR 0279 in Bear County, Texas, the defendant was convicted of the felony of murder.
All right, how do you plead to that, true or not true?
It's true.
I have about 8 years of service, and currently I'm assigned to the narcotics unit as a plainclothes detective.
And is that with the San Antonio Police Department?
Yes,
And were you on duty on August 25th of 2019?
yes. And at the time, I was employed with the street crimes unit for the San Antonio Police Department in a uniform officer capacity.
And being on the street crimes unit, can you tell us a little bit about what that entails?
We were assigned areas of town, and basically we go there. We get assigned there because there would be issues with crime. So we go make apprehensions for either narcotics trafficking or any violent crimes, robberies, or vehicle theft, or things of that nature.
And on August 25th of 2019, were you alone or did you have a partner?
I have a partner.
At some point on August 25th of 2019, did you come into contact with Kenneth Williams?
Kenneth, I don't recall that name, but I have several other names of the defendant that provided to me.
And what name was provided to you?
Due to the report, there was a Germany Williams spelled several different ways.
I'm going to object to him reading from his report.
Sustained.
Detective Trevino, did you create a report in response to this incident?
That is, yes.
And would seeing a copy of your report refresh your memory?
Yes.
Your Honor, may I approach?
Yes.
No, 74. I'm going to mark your report as State's Exhibit 74. Just use it to refresh your memory, but please don't return it, okay?
Okay, Detective Trevino, what was the name of the person that you came in contact with?
Germany Williams.
And how did you come into contact with him?
We initiated a traffic stop. The vehicle he was operating was about a year old. Registration was about a year old.
And Detective Trevino, when do you know when the registration was expired? Do you know the date?
I can't recall the exact date, but it was a year prior to contact with the defendant.
And how do you guys usually confirm that?
Usually with our computers that we have on our patrol vehicles, we'll run the license plate and it'll tell us. And then also there will be a sticker that will verify on the physical sticker on the vehicle.
And is that why you initiated a stop for Germanic Williams?
Yes.
Okay. And after you initiated the stop, what did you do after that?
We tried to make contact with the defendant, but he parked pretty quickly and then tried to distance himself from the vehicle.
Okay. So after he started walking away from his vehicle, were you able to contact him?
Yes.
And what did you do then?
We contacted him, detained him. Just the fact that he was distancing himself from the vehicle, he was kind of making furtive movements, walking away from us. At the time we had a marked patrol vehicle with lights, and I don't recall if we hit the siren, but typically we'll do that for people not wanting to make contact with us or initiating a traffic stop. So at that point he was detained.
And is that standard procedure for SAPD?
Not only is it standard procedure, it's kind of an officer safety concern as well.
And after you detained him, did he provide you his name?
He provided me a version of the name, yes.
And when you say a version, what do you mean?
It was just a different spelling, different date of birth.
Were you able to find him in the system?
Not immediately.
When were you able to find him in the system?
It took me several tries and then several times going back to speak with him and then trying to get him to clarify his date of birth and the spelling of his name.
So was that information that you were given, was that provided by Mr. Williams?
The correct information was provided after a number of attempts to get that from him.
But he also provided you false information?
Yes.
Okay. So after you were able to locate him in the system, what did you do after that?
So after that, he failed ID to someone he knew was a peace officer on duty. And then at that point, he was arrested for failed ID, false or fictitious info. And then from there, we went to search the vehicle.
And did you find anything when you searched the vehicle?
Immediately when I opened the door, there was a bag of alleged narcotics.
And sorry, detective, why were you searching the vehicle?
He was just a person under arrest due to the fact that he tried to distance himself from the vehicle. On top of that, typically we'll tow a vehicle. I think at that point he was under arrest. Typically when we tow a vehicle, we do have the authority to inventory what's in there as well. I mean, I didn't get to that point because immediately when I opened the door, which if he would have been in his vehicle when we stopped him, I would have opened the door the way. So that would have been, it doesn't play me once I opened the door.
And what did you find in the driver's door?
It was a bag of alleged narcotics.
And what did you do after you found the narcotics?
At that point, we recovered it, and then later on in the process, we field tested it, which field tested positive for the presence of cocaine.
And do you remember where you pulled him over? Was it an address or the intersection?
I don't recall the address, but maybe a street name, Lockhart.
Okay, and you can refer to your report if that helps. Do you know where you pulled him over?
Yeah, Lockhart. I don't know the block number or anything, but. Yeah.
And is that here in Bear County, Texas?
Yes, it is.
And as far as the person that you arrested, Germanic Williams, do you see him in the courtroom today?
Yes.
Can you point to him and identify him by an item of clothing?
Defendant's wearing a black long sleeve shirt.
You want to make the record reflect who's identify the defendant? Just a second, Jackson. Detective, did the defendant make any, comments about his vehicle?
Well, initially said it was not his.
And did that change?
Toward the end, he said it was his after the fact, after you got his correct name, so
He said that the vehicle was his.
it's at the end of the investigation.
We'll pass the witness.
Right, defense?
Officer, you have your COBAN video on all times during the stop.
So it's,
And that COBAN video not only showed the outside, what was going on, but also had in the cab of the vehicle. Is that correct?
in the rear seat, sir.
Right, so you can see actually what was going on in the dash of the vehicle. Is that correct?
The dash of the defendant's vehicle,
No, your vehicle.
it leads out the front and then we have a camera in the rear.
It can see the computer, right?
I don't believe so, no, sir.
All right, we got a video. And we can play that video and think real hard. Isn't it a fact, sir, that you did not run the license plate of that vehicle until you made 2 U-turns, followed the vehicle, found it, and then looked at the computer once you were stopped, ran the license plate, and then hit your lights? After,
I don't recall that, sir.
you don't recall that? We can look at the video of that.
Okay.
All right, Judge, how do we play a video?
All right, if you would like for him to review the video.
I can do that. We can play the video for him to look.
All right, State, has your witness had a chance to review the video?
Is this, which,
This is the video of the stop where they run the license plate after they stopped him, not before.
can you specify, is it the body cam or dash cam?
It's the dash cam in the vehicle.
All right, so this is what we'll do. Mr. Turek, if you could please have that marked. And State, if you'll have your witness have a chance to view defense's exhibit. What number will that be, Mr. Turek?
This would be number 1.
All right,
And I've got, unfortunately, it's got a number of videos on it.
all right, so we'll have your witness have a chance to review that, and then Mr. Turek can ask your questions.
Okay.
So if the witness, if you could step down, the way to view it will be on the computers at that desk, Mr. Turek.
All right.
I can see it on my screen since you're on the share screen.
Okay.
Yes.
On State Exhibit 1, this is video 8. Now showing, of course, Exhibit 1, video 2B. And this is the 1, video 4. Your Honor, the defendant, Mr. Williams, was convicted by the jury of 2 counts of aggravated assault.
Do you want to stop screen share?
Yes, sir.
Thank you, sure.
Your Honor, Mr. Williams was convicted of 2 counts of aggravated assault by the jury. I understand that they are assault by threat, and usually, I guess, people tend to see that as a lower offense, as opposed to bodily injury. On its own, it is a secondary felony, so the range would be 2 to 20. Looking at just count 2, which he was convicted of, the motor vehicle, I could see a situation where someone could try to rationalize his actions in that situation. He had just been punched by the victim. Victim was standing in front of his car. He could have backed up, but maybe he was still in the heat of the moment, and he drove forward. As you can see in the video, he still attempted twice to run the victim over, no matter how the victim tried to get out of the way. That case alone, I would probably say somewhere in the lower range would be appropriate. But we also have count 1 that he was convicted of, aggravated assault with a firearm. This is, in my opinion, the maximum. Like, this is the highest that it could be as far as an aggravated assault by threat. He goes into the building with at least 3 people, as you can see in the video, and fires off multiple rounds, 12 casings that they found. It was at best his intention to commit an aggravated assault bodily injury. At worst, it was his intention to commit murder. And this could have easily been a capital murder. Like I said, there were 3 people inside. He then fired 2 rounds outside of the vehicle. Who knows where those rounds could have gone? Or sorry, outside of the store, who knows where those rounds could have gone? It could have hit anyone. His actions were egregious, and if this were just a secondary felony, we would be asking for 20. However, he's played true to the enhancement paragraph, which bumps us up to a first degree range. We're looking at 5 to 99. So we'd ask the court to consider what his prior felony was and the punishment that he received if he was convicted of murder. As you can see, he pled not guilty and went to trial. The jury found him guilty of murder, and he was sentenced to 30 years in 1997. Doing the math, that means he's still on parole for 5 years. He's been out, I'm not sure exactly when he got out, but he's out on parole and he's still committing offenses. In punishment, we proved up that he also possessed drugs, crack cocaine in an amount of 4 to 200. And so, Judge, I guess our argument is that Mr. Williams has shown that he has no regard for human life. He's committed a prior murder in the past. He gets out while on parole and he tries to commit another one. We are asking for the maximum life on this case, Judge.
All right. Defense, it's the court's understanding that you are not requesting a pre-sentence investigation. Is that correct?
That is correct, Your Honor.
All right. And State, do you have any objections to proceeding without a pre-sentence investigation?
No objection, Your Honor.
All right,
Judge,
All right. So the State will hear your argument, defense.
may it please the court.
Oh, and Mr. Chirek, you can remain seated. I don't.
See,
Yes, I don't take that as a sign
I'm
of
old
disrespect.
school.
I understand. I don't take it as a sign of disrespect. It's just easier for the microphones to pick up and for Brenna to hear.
Gotcha, Your Honor. I'd like to address some of the points. Judge, with regard to the prior murder conviction, if the court will look at the record of that, he was not the shooter. He was actually indicted as a party because he was at the scene.
Your Honor, I would object to facts, not in evidence.
Just a moment. Could I see State's Exhibit number 78-6, I believe? Thank you. I'm so sorry, Brenna. Just a moment. Let me do this again, and then I will on State's objection. All right, Mr. Chair, it appears that the indictment states that Mr. Williams, according to the indictment in State's Exhibit number 76, it stated that Mr. Williams shot at the complainant. That's what's in the indictment.
Yeah, because the indictment's going to say that basically because they don't allege party, they just allege the violation in the indictment.
Well, I'm going to sustain the state's objections, because according to state's exhibit number 76, the argument that you're presenting, it is not on the face of state's exhibit number 76.
That's not true. Judge.
Mr. Church, would you like to review state's exhibit number 76 to show to
I've got
Mr.
it in front of
Williams?
me, Judge.
All right.
Okay. Okay, in addition, Judge, basically with regard to the drugs, I believe that they were found based upon an illegal search. I was clearly, Detective Trevino said that they followed him before they ran the license plate, and then when they were actually stopped, ran the license plate to determine that the sticker had expired. So we believe that any drugs found would have been the fruit of an illegal search and therefore should not be considered by the court. We'd ask the court to use their judgment and years of experience in sentencing the defendant in this case.
All right. And no evidence was presented to the court on this point, but how old is your client, Mr. Churek?
Pardon, Judge?
How old is your client?
I will leave 41. She's 41, Your Honor.
All right, state argument?
Judge,
Any rebuttal?
I would just point out that, and I can't remember if I said it initially, but he was sentenced to 30 years and that hasn't prevented him from committing new offenses. And so we would ask, if you aren't going to sentence him to life, that it would be higher than the 30 years.
Was a kid at that time.
Excuse me, who's waiting from the back of the courtroom? From that door? The person who's in that shirt, who is that?
Have a seat, sir. Are you gonna come in? Have a seat and just wait.
Thank you.
Your Honor, my
Yes.
client is insisting that he address the court.
Well, both the state and the defense have rested and closed, Mr. Jurek.
I agree, Judge.
All right. I mean, if the state has no objections, but then Mr. Williams, that would subject you to cross-examination. Do you want to speak to your client?
I've already advised him, Judge, that if he speaks, the state can question him.
Did either party want to speak to count 4?
That's the one that's got the joinder, right, Judge?
Yes.
So that would be an issue because we do not know what the jury determined which party was potentially subject to the deadly conduct. And since they found him on the aggravated assault, there would be an issue of an election on that particular case because the elements would be clearly the same. So we don't know whether, they found for deadly conduct against Williams and Muhammad, or Muhammad alone, or Williams alone. So I think, Judge, that's an issue with the finding on that. It's inconclusive.
Judge, our concern is, it's a lower offense, even with the enhancement, it's the second degree, and so I'm not sure how the court would like to proceed, but we would have no objection to, I guess, whatever is appropriate.
All right. Are you requesting that count 4 be set aside? State and defense, are you objecting if the state is requesting such?
No, if they're requesting count 4 be set aside, I have no objection.
Yes, Judge, that is our request.
All right, then count 4 will be set aside. And then that leaves count 1 and 2. On count 1, court will sentence you to 40 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. And count two, the court will sentence you to 40 years in prison, give you credit for any time served, and there's an affirmative finding of deadly weapon. Just one moment. And the court will note that both parties agreed to set aside count four. And counts 1 and 3 will run concurrently.
1 and 2.
I'm sorry, 1 and 2. Thank you. Is there any restitution?
Not the real.
Is there anything else from either side with regards to sentencing? State,
Nothing from the state.
defense?
Nothing to defense, Your Honor.
You have your hand raised, Mr. Williams?
Yes, Your Honor, may I speak?
No. If it is about this case, no. The court has passed its sentence.
Yeah, but my rights been violated in this courtroom. My
Mr.
Sixth Amendment been violated.
Excuse me. Did you review trial court certification with your attorney? Did you understand it?
Yeah, you found me guilty without a victim.
All right, because,
That's violating the Constitution right to my Sixth Amendment.
all right, Mr. Williams, first, number one, you need to lower your voice. Number two, I did not find you guilty.
Yeah,
A
the
jury
did.
found you
They don't know
guilty.
the law. You know the law. You should uphold the Constitution right.
All right. So is there any victim impact?
No, Your Honor.
All right.
Kenneth Williams was stopped by San Antonio police in August 2019 after officers noticed his vehicle had an expired registration. When officers approached him, Williams walked away from his car and gave officers a false name and false date of birth multiple times. Once his true identity was confirmed, he was placed under arrest for providing false information to a peace officer. During a search of the vehicle, officers recovered a controlled substance later confirmed by a crime lab chemist to be cocaine, weighing 4.598 grams. At trial, a jury found Williams guilty on 2 counts of aggravated assault, one involving a firearm discharged inside a building with multiple people present, and one involving a motor vehicle used against a victim. Evidence also showed Williams had a prior felony conviction from 1997 and was still on supervised release at the time of these offenses. Judge Stephanie Boyd sentenced Kenneth Williams to 40 years on each count, to be served at the same time.